Welcome to Pocket Chat number 3, sponsored by the Joint Task Force of the Chicago Bar Association and Chicago Bar Foundation on the sustainable practice of law and innovation. I'm Mary Ann Mason. With Lynn Grayson, I co-chair the task force and have conducted several of these pocket chats to discuss the task force recommendations. My guest today is Judge LaShonda Hunt. Judge Hunt is a judge of the Federal Bankruptcy Court here in the Northern District. And Judge Hunt was kind enough to chair the Limited Scope Representation Committee. Welcome, Judge Hunt.
Thank you, Justice Mason. Glad to be here.
Very nice to see you virtually.
Right, it's been a while.
So before we talk about the committee's work and the committee's recommendations, for somebody watching this pocket chat who might not be familiar with the concept of limited scope representation, can you tell me what that is?
Sure. So we typically think about a lawyer taking on a case and representing the client from the beginning to the very end. But with limited scope representation, we're really looking at lawyers taking very discrete parts of a case. So for instance, a child custody hearing that might be part of a larger divorce proceeding, but the lawyer is just there for the child custody portion of it. And what limited scope allows is for the client to hire the lawyer for certain services. And that scope of services would be negotiated and fully documented, and the client would pay for that scope of services, that limited scope there. And so the idea is that for clients who need lawyers for particular types of motions or hearings, they can have an attorney for that, and then they can represent themselves for the rest of the proceedings, and it would hopefully be more cost effective. And certainly the lawyer would still comply with all of his or her professional and ethical responsibilities, but it gives each of them a chance to, it gives the client a chance to have the lawyer when they need it, and the lawyer to provide this limited service.
Limited scope representation has been authorized under the Illinois Supreme Court rules since 2013. Anecdotally, what has the experience been with that representation?
What we have heard is that there are lawyers who have undertaken that experience and they have enjoyed it. Our evidences or our responses are pretty limited because we haven't studied it fully. We haven't been able to collect all of the data. But one of the big points that has been raised is the idea that lawyers are concerned that judges won't let them out of the case once their limited scope of representation is over with.
The first recommendation that the committee came up with was to streamline Rule 13 of the Illinois Supreme Court rules, particularly focusing on the lawyer's ability to withdraw. Tell me how the committee came to this recommendation.
So we started thinking about how do we address the lawyer's concern with not being certain that he or she can withdraw from the case. And so we talked about, it made sense to recommend a change in the rules. And so the current rule has two options for withdrawing from a limited scope representation. The lawyer can either do that in court while the client is present and hope that the judge will say, yes, you can withdraw. Anecdotally, we had heard that some judges would say, no, you're not going to be allowed to withdraw. So that was a little, bit of a challenge. But also, so they can withdraw in court. They can also withdraw by filing a notice of withdrawal and setting that out for hearing within after 21 days. So there was really this concern that I think we were trying to address from the lawyer's perspective, that if they take on this limited scope representation, that once they have fulfilled their end of the bargain and provided all of the services that they contracted to provide to their clients, that they would have a more immediate way to be released from the case.
So in the committee's recommendation, instead of the typical motion to withdraw, what mechanism has the committee recommended for the lawyer's exit from the case once the services have been completed?
So we recommended a notice, just a notice that says of completion of the limited scope representation, which the lawyer would file and could file with the client in open court or simply file it. But the difference here is that the termination of the representation would be immediate. So there would really be no need to go through the second step of filing essentially a request to withdraw. So that was the whole point, is that we wanted lawyers to know for certain that once you have provided the services that you've agreed to provide to the client, then you will be released from that representation, and it will be immediate. So they're not waiting and wondering, do I still have a client that I'm supposed to be representing? Will the judge agree or won't the judge agree?
You mentioned that anecdotally, the committee had heard of instances where judges were reluctant to let an attorney out of the case, even though a limited scope appearance had been filed, and even though the attorney represented that the services contracted for had been completed. How did the committee address this problem?
So one of the points that the committee talked about was the need for more educational programming around this idea of limited scope representation. One of our concerns was that maybe judges don't know about this and don't fully understand what it involves. I mean, as judges, we're all pretty used to the attorney comes in and stays in the case from beginning to end. And so one of the recommendations that we made was that hopefully the administrative office of the Illinois courts would perhaps consider including educational programming for judges as part of the training, the new judges training, or the biannual training that is done, so that we at least get judges more familiar with this practice.
What about educating attorneys about the availability of limited scope and law students about that aspect of the practice of law?
Right, absolutely. The committee considered and decided to include those two recommendations as well. I mean, certainly with practicing attorneys, we're all experiencing the turbulence of a global pandemic and the need to really think about the practice of law and how services are delivered. And so the idea was that, we needed to have educational programming for attorneys around, what your ethical and professional obligations are with limited scope representation, and how do you accomplish that, and what is the court process like. So doing that for practitioners, we thought would be a great way for them to think about perhaps how they could maybe expand the scope of their practices. And then with law students, it's so key to get them aware of this opportunity, even when, they're still in law school and studying professional responsibility obligations. We thought that this would be, a great subject that could be covered there as well and incorporated into the current curriculum.
Since 2013, when limited scope representation was incorporated into Illinois Supreme Court Rule 13, has there been any effort to measure the effectiveness of this new form of representation?
Yes, there has been. So the courts have required the clerks of court to document this information and provide numbers on how often is this being used. So the request is out there, but I don't think that we as a committee saw that this was really being responded to, because in many instances we were told that the clerk's office would report 0 cases when we know anecdotally that limited scope representation is being used. And so it seems like there's a disconnect somewhere in terms of how do we measure if it's being used and if it's really effective.
So is one of the committee's recommendations focused on gathering data regarding the effectiveness of limited scope representation?
Absolutely. Currently, the clerk's office is supposed to provide this quarterly data. And so one of the recommendations that the committee has made is working hand in hand with the circuit clerks to figure out what is the best way to collect that information. And hopefully now that the state has switched over to e-filing, we've recommended working with the vendor who supports that technology to see if there's a way to actually track the number of limited scope appearances that are being filed.
There is actually a standardized form for a limited scope appearance, isn't there?
Yes, there is.
So it would seem that the clerk's office could probably track those with not a lot of difficulty.
Right, and that was the committee's hope. We certainly are not trying to, put more work on the clerk's office staff than is needed here, but there are forms, and we thought that perhaps working together, we can come up with a way to actually measure the use of this form.
The last recommendation the committee made was expanding limited scope into the federal district court where you sit. Is it currently not authorized?
So no, actually limited scope representation is not really authorized under the federal rules, except in some limited instances relating to pro bono representation.
And did the committee conclude that expansion of limited scope in federal court would be advantageous?
We did. We definitely did. There are certainly cases where limited scope representation could work in federal court. For instance, a summary judgment motion, which can be very discreet. A motion to dismiss at the very beginning of a case is another good example. And so the committee recommended that the federal courts start to look at the Illinois state court rules to see how it's working on that side. And the federal district court in Colorado has actually adopted rules surrounding limited scope representation in federal courts. And that would provide another great example for the federal courts to look at and see if perhaps there are some good suggestions that could be taken from the experiences of that district court.
Well, Judge Hunt, thank you so much for talking about the not so limited recommendations of the Limited Scope Committee. And I thank you for chairing that committee. It's been a pleasure talking to you today.
Thank you so much, Justice Mason. It was my pleasure to chair it, and I really am excited about seeing some real changes in this area, because I think it would do quite a bit to really advance the administration of justice and provide an opportunity to help attorneys develop a more sustainable practice of law.
Thank you. Excuse me. And for those of you watching this Pocket Chat, you can learn more about the task force work by visiting the Chicago Bar Foundation's website at chicagobarfoundation.org. There you can access the entire task force report, more pocket chats about task force recommendations, and most importantly, the public feedback form. You can submit feedback about the task force's recommendations in writing on the website, or you can participate in one of two virtual public hearings about the recommendations during the month of August. We really would like to hear from you, whether you agree or disagree with the recommendations. Please give us your feedback. Thank you so much.